Ladies and gentlemen, buckle in, because today's case is a whirlwind of tension, contradiction, and courtroom drama that will leave you questioning everything you thought you knew about self-defense and justice. We're in Texas, where the ED stakes couldn't be higher. The defendant, Anette Idago, stands accused of aggravated assault with a deadly weapon. Already, the mere mention of a deadly weapon raises the seriousness of this trial to a whole new level. Now here's what makes this case especially gripping. Anette has pled guilty, but her story doesn't stop there. She insists that what happened wasn't a crime at all, but an act of self-preservation. She claims she was fighting for her life, but the prosecution, and soon the evidence, tell a very different story. In the coming minutes, you'll see a courtroom filled with family, tension so thick you could cut it with a knife, and a judge determined to separate truth from excuse. You'll hear Anette herself break down in testimony, wavering between self-defense and guilt, a contradiction that could be her undoing. And if that wasn't enough, a video emerges mid-trial, a video that could be the nail in the coffin. So, here's the big question I want you to keep in mind. When does fear cross the line into violence? At what point does self-defense become aggression? Was Anette truly cornered, or was she the aggressor with a knife in her hand? Stay with me as we unravel this tense courtroom showdown. And as you watch, ask yourself, if you were in the judge's chair, how would you rule? Let's dive in.
All right, this is for sentencing, correct?
It is, Your Honor. Yes, it's PSI.
All right, who's the prosecutor on Anette Idago?
You guys.
Is this criminal trial division?
Yes, Your Honor.
All right, Jason, are you on this?
Yes.
Okay. Everyone, we're going to go on the record. So, counsel, if you can ask the deputies, they'll move you down there. You're welcome. And do not, as a reminder.
Here, the judge formally calls the case, State of Texas versus Anette Idago. Notice the procedural formality, case number, charges, and the attorneys announcing themselves for the record. These steps might seem mundane, but they're crucial for legal clarity. This is where the courtroom drama shifts from speculation to fact. What stands out already is that the prosecution is remaining silent on certain issues like deferred adjudication. That's interesting. It suggests they're confident the facts alone will sink the defense. Quick question for you all. Do you think a prosecutor should ever stay silent in a sentencing hearing, or should they always push hard for the harshest penalty? Drop your thoughts below.
Do not approach the bench or the coordinator or the clerk when we're on the record. Court is calling 2023 CR 7274, State of Texas versus Anette Idago. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Good morning, Your Honor. Daniel De La Garza for the defendant.
And are you Anette Idago?
Yes, ma'am.
You entered a plea of guilty on November 16th. According to the plea bargain agreement, punishment is to be assessed at 9 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor, we're reviewing it right now, but since we're silent, I'm fine with reviewing it and then go on.
All right. Defense?
I have reviewed it, Your Honor, and showed the same to my client.
All right. Any objections to the PSI report? Defense?
No, Your Honor.
All right. All right. The state is silent. Defense, do you have any witnesses?
We don't have any witnesses, Your Honor. I would just like to point out that Ms. Idago's husband is in the courtroom.
Okay.
Her father is also in the courtroom. He's standing. She has a supportive family, that kind of stuff.
Okay.
I don't think the testimony is necessary. I can argue it, and it's in the PSI.
Okay.
But so we have no witnesses.
All right. Well, if you want to address with your client, because there's where it says guilt acknowledged, there's an X there, which I'm assuming guilt is acknowledged, but there is also an X that says guilt is minimized.
And I could ask you some questions, Judge. And
Sure. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Anette Idago.
All right. Make sure you keep your voice up so that the court reporter can hear, all right? All right, defense.
thank you, Your Honor. Okay, and you know you're here for sentencing today, right?
Yes.
And you pleaded guilty to aggravated assault with a deadly weapon,
Yes, sir.
right? Now, tell the judge at the time, and it's in the PSI, we talked about it, but tell the judge at the time that this was happening, what was going through your mind?
Self-defense, Your Honor. I
And-
was simply trying to defend myself. I'm sorry.
Okay, that's fine. And then now, since I've become your lawyer, you've looked at the evidence and all that kind of stuff.
Yes.
Have you realized now, do you know whether it was self-defense or not?
Yes.
And you think that it was not, or do you think it was
I
self-defense?
believe in my heart it was self-defense.
Now, do you take responsibility for what happened, though?
I do know now that it's, in my mind, in my heart, it's self-defense.
But you know now that
But
it
I
was,
know, yes, sir.
tell the judge that it was
I
what?
do know now.
All right, so I'm sorry, if
Yeah,
you all
I mean, yeah.
can slow down and one at a time.
So tell the judge whether you think now this was self-defense or whether this was illegal.
I know now it is illegal, but at the time it was self-defense.
All right, so then the question is, do you take responsibility and do you acknowledge the guilt for the aggravated assault with a
Yes,
deadly
sir, I
weapon?
do.
Hold on, aggravated assault with a deadly.
This is a turning point. Annette admits she knows now her actions were illegal, but insists, deep down, she believed she was acting in self-defense. That contradiction is everything in this case. Why? Because a guilty plea with a self-defense claim doesn't make sense. They're mutually exclusive. Either you're guilty of aggravated assault with a deadly weapon, or you were justified in defending yourself. The fact that she waffles between the two could seriously damage her credibility. If you were the judge, would you buy her explanation? Or does it sound more like she's trying to play both sides?
Weapon case. Do you acknowledge your guilt?
Yes, sir.
And what are you asking the judge to do today?
If I would please get probation. It's my first offense. I simply was scared for my life, trying to defend myself.
And tell the court, why should the judge put you on probation?
Like I said, I know now if this would never happen again.
First off, right?
Right.
Do you have a criminal history?
No, sir, I don't.
Maybe a very limited one from Hidalgo County, like a harassment or something that's on the PSI?
none of that.
All right, everyone, one at a time. Okay, go for it.
Okay, and if you're granted probation, do you know that there's terms and conditions that come along with it?
Yes, sir, I do.
Are you going to follow all those terms and
I'm
conditions?
willing to comply all the way.
Are you going to use drugs while you're on probation?
No, sir, I don't use drugs.
You don't have a history of drug
No,
use, right?
sir.
Are you going to work?
Yes, sir.
And the
Work.
PSI says that you're a caregiver, right?
Yes, sir.
Are you able to go back to some kind of job like that?
Yes.
Now, what if the judge says you're not able to work as a home care provider or anything like that? Are you able to find other kind of employment?
Yes, whatever suitable for me.
Where would you go live?
My parents at the time being.
And do they live in close proximity to Miss Tracy Hernandez?
No,
If the court orders you to stay away from the complainant in the case, would you stay away from her or would you go back to the Goodwill and?
no, I have no business. anymore.
Is there anything else that you'd like to tell the court before we stop?
Just that I'm truly deeply sorry, and I know now that all I was trying to do was defend myself. It was simply self-defense. I'm a mother of 5 kids and I'd like to go back to see my kids. I didn't see them for Christmas, Thanksgiving.
Annette now makes her plea: probation instead of prison time. She stresses her clean record, her role as a caregiver, and her responsibility as a mother of 5. This is a classic defense strategy, humanizing the client, showing ties to family, community, and employment. But here's the catch: aggravated assault with a deadly weapon is not a minor charge. Judges rarely hand out probation in cases involving knives, guns, or other deadly weapons. Would you take the gamble of probation? Here, Or does the severity of the weapon outweigh her personal circumstances?
Thank you, Your Honor.
All right, any questions? All right, I do. The police report says that you were chasing her with a knife,
No,
and
ma'am.
they say that there's a video of you chasing her with a knife.
No, ma'am, I did not chase her with a knife. I was simply scared running because there was two women after me. Not only one, two.
All right, am I,
Well, Judge, I don't know really what to make of this because lots of times we can say, well, the person has a mental illness, health, issues. They're on drugs. I don't know really what to make of this other than it's a one-time kind of incident thing.
where's the video?
It's in the discovery.
Any objection to the court seeing the video? Just, if you all have it, if I could see the video?
At a time.
Sure. Because she's saying self-defense, and I'm being told that the video,
And I
there's a
think-
video that shows something differently.
Yes, Your Honor, but I think now she realizes it's definitely not self-defense. This is
Okay.
not a self.
All right. So what I want to know is whether or not she was chasing somebody with a knife or not.
Probably I was scared, ma'am.
No, you said you were running from two women,
Yes, there were two women after me, ma'am.
but
And
the police report says that you were chasing the complainant with a knife. So were you chasing the complainant with a knife or no?
yes, to defend myself and run from, there was two women to defend.
If somebody's running away from you and you're chasing them with a knife, how are you defending yourself?
No, there were two women and one of them were after.
Boom! This is where the prosecution's narrative collides directly with Annette's testimony. The police report says she was chasing someone with a knife. Annette denies it until pressed, and then she admits it but calls it self-defense. Here's the legal bombshell. In Texas, self-defense doesn't apply if you're the aggressor. If the video shows her pursuing rather than fleeing, her entire argument collapses. This moment right here, it's the crack in the defense's foundation. Stay tuned, because the video is about to decide everything.
Me.
Okay. All right. Well, we'll see the video, see what the video shows. All right.
I just saw the view, and so happens about halfway through.
Okay.
Roughly, but it kind of slowly.
Okay, let's pause it and I'll let you offer it into evidence.
Judge, and just to protect the record, if I could, I'm just gonna say because the court's requesting it, because since they're silent, so it doesn't look like they're
Sure.
not.
All right, we're going to go back on the record. And cause number 2023 CR 7274, State of Texas versus Anette Idago. The court had requested a video and for the state.
Daniel Escobar for the state of Texas.
All right. And defense, this video was actually mentioned in the stipulations to the court. Defense, are you offering the video?
Yes, Your Honor.
All right. And so this will be marked as defense exhibit number 1. And the court will view the video. And I'm being told that the incident occurs at the halfway mark.
Well,
All right. Counsel, any objection to the court fast forwarding?
No, Your Honor.
And who is your client, counsel?
Believe the lady with the hat.
Let me pause it. Ms. Idago,
Yes, ma'am.
what are you wearing in this video?
Um,
Are you the person in the black shorts?
no, ma'am.
Are you the person with the burgundy top? with the
Mm,
blondish hair?
No, ma'am.
Are you the person in the gray shirt with blue jeans with the white hat?
I think so, yes.
And who is the person next to you?
The other lady.
Did you catch that hesitation? Annette struggles to even identify herself in the footage, almost as if distancing herself from her own actions. But ultimately, she admits, yes, that's her. This is devastating for the defense. When you're caught on tape, denial becomes almost impossible. And for the judge, credibility is everything. Once a defendant wavers on their own identity in video evidence, it's very hard to recover.
There were two ladies who approached me. I'm not sure. No, it wasn't. It was,
Okay.
something else.
So are you saying you're the person with the white hat with the check and the gray top and blue jeans with the white shoes?
I believe so, Your Honor. Not sure. I can't really see.
Springfield start coming like scuffle,
Okay.
not a melee. So no.
I'll make sure you speak up because
Oh, it's
the court reporter, we're still on the record. Okay, let me, just 1 second.
See, she's on it.
Hmm. All right. All right. Any questions from the state? Yes. All right, defense.
Just a real brief argument, Your Honor.
Okay.
What we're asking you to grant Ms. Idago's application for deferred adjudication. You saw the video, Your Honor. In her mind, it was self-defense. I certainly understand the chase and all that kind of stuff. And
Now, the defense makes one final push. They ask the judge to grant deferred adjudication, a type of probation that, if completed successfully, wipes the conviction from your record. They argue Anette needs anger management and supervision, not prison. It's a bold ask, but remember, the judge just watched the video of her chasing someone with a knife. What do you think? Does rehabilitation outweigh retribution here? Or should the consequences match the severity of the crime?
and she now understands how it is not self-defense. Nonetheless, Judge, she definitely takes responsibility for her actions. She's asking to be supervised by the court. I think she would benefit from some anger management and classes that help her deal with these kinds of situations and how to get herself out of these kinds of situations. So the long story short is, Your Honor, based upon her limited criminal history, her lack of drug use, the fact that she takes responsibility, we ask that you grant the application. Thank you.
Anything else you wish to say? Mr. Drago?
I just ask that God may touch your heart and understand that like the all I was asking is that if the Lord could hear me right now, he'd understand how much I repent of what happened that day. But it simply is just a self-defense in my mind, even though I know it's wrong.
Okay.
Thank you, Your Honor.
All right. Thank you so much. All right, so this is what the court is going to do. The court has heard all the evidence, and I want you to know that I internalize everything and I look at cases on an individual basis. The court is going to deny your application. Court will find you guilty.
And there it is. The judge denies probation and deferred adjudication, sentencing Anette Idago to 3 years in prison. Why? The video evidence, the contradictions in her testimony, and the seriousness of aggravated assault with a deadly weapon. The court also makes an affirmative finding of deadly weapon use, which carries long-term consequences, like restrictions on owning firearms in the future. So, what do we take away? This case underscores how critical consistency is in the courtroom. A guilty plea mixed with a self-defense claim simply doesn't hold water. The video, combined with the defendant's contradictions, sealed the deal. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you won't want to miss what's coming next.
Court will sentence you to 3 years in the prison, give you credit for any time served. Take in consideration NIMAC number 714. 465, night mag number 723973. There's an affirmative finding of a deadly weapon. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Counsel.
Walk around.
Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Maybe excuse, Your Honor.
Yes.
Thank you.